There are a number of aspects of Michigan law that are very friendly to property owners and that are different from other states. These include the fact that evidence about just compensation is liberally admitted. For virtually all types of just compensation, there's no burden of proof, and reimbursement of both the contingent attorney fee and expert expenses. There are other classes of just compensation that are not recognized in other states. One of those includes the cost to avoid business interruption. Let's go and look at some examples in Detroit in which property owners were entitled to recover their costs to avoid business interruption. We're outside General Motors factory in Hamtramck. The acquisition for the property to allow the construction of this factory was a critical case in the evolution of Michigan's public use laws. Today, we're here to talk about costs to avoid business interruption and the just compensation issue that arose as a result of one of these takings. The Hamtramck Federal Credit Union was located in the boundaries of this factory. Due to the speed with which the acquisition process occurred, the credit union was forced to move twice. The Court of Appeals upheld the awarding of costs to avoid business interruption for 2 moves, as well as additional expenses, including costs incurred to attract and retain membership. This case was important for 3 critical reasons. First, it helped define what type of expenses are recoverable under the rubric of costs to avoid business interruption. Second, it affirmed that the property owner did not have a burden of proof to establish that type of just compensation claim, and there was no burden of proof in establishing just compensation. And finally, it reaffirmed a long-standing precedent that evidence of just compensation is to be liberally admitted in eminent domain cases. Next, we'll go a little bit south to Cobo Hall, where another business interruption case occurred. We're outside of Huntington Place, which used to be Cobo Hall. The city of Detroit used eminent domain to expand the facility. One of the properties it acquired was a furniture distribution center. Initially, the jury awarded $3.2 million. However, the Michigan Court of Appeals reversed that verdict. It disallowed what it classified to be lost profits. However, it reaffirmed its prior holding that costs to avoid business interruption were recoverable. The Court of Appeals upheld the verdict as it related to costs to relocate, similar to the Hamtramck case, but also things like the advertising expenses that the business would incur in reestablishing itself in a new location. In order to maximize a property owner's just compensation recovery, it's necessary to understand the full menu of options that are available. The cost to avoid business interruption is perhaps the most common example of non-real estate based just compensation that is available to a business.